Hi, and welcome back to Focal Point AFR Talk. Great to have you along for the ride. Dr. Mortensen, by the way, next hour has agreed to stay for an extra segment. If you have questions you would like to ask him, I'd like to keep the questions specifically on the age of the Earth. It might have to do with radiometric dating, some of the stuff that we are going to talk about. But if you want to ask an expert questions that deal with the science and the age of the Earth, just an hour from now, that'll be your opportunity to do it. We'll open up the phone lines for your questions for Dr. Terry Mortensen, if you have them. So he'll be with us for the first half hour, starting at the top of the next hour, right after the news. We'll go to the bottom. He'll rehearse for us some of the main scientific evidences for a young Earth. And any questions you have, you can ask him at the bottom of the hour, and he will be happy to answer them for you. Now, let's see, a couple things I want to deal with here before we move to that. Still staying with the issue of religious liberty, you've got some schizoid rulings being issued by federal judges right now with regard to the Obamacare abortifacient mandate. Now, one of the most egregious was regarding Hobby Lobby. There's a federal judge in Oklahoma City who yesterday rejected Hobby Lobby's request to block the part of Obamacare that requires them to provide abortifacients, the morning after pill, RU486, the Ella pill, to their employees. They said, look, it violates our Christian conscience. There's no question about Hobby Lobby. This is not, this isn't them just using this as a ruse to try to get out of some cost here. I mean, they genuinely are a Christian organization run by Christian principles. They close their shop. They close their stores on Sundays every week in honor of the Lord's Day. So, I mean, they're serious about this. They're genuine. They're one of our blue stores for Christmas. I mean, they really get into the Christmas thing at Hobby Lobby. We're recommending that people shop there. Belk is like that. The AFA online store is like that. Walmart is like that. And so we're encouraging people to shop at these places. Lowe's is like that. Shop at these places that are making a point of connecting their seasonal advertising to Christmas. But here's what this judge said. This is what really irritated me the most. This is a federal judge. And ladies and gentlemen, if you will listen to me over about the next 60 to 120 seconds, you will know more about the Constitution and the First Amendment than this judge. You would be in better position to render a call on this case than this federal judge, because he's talking about the Constitution. Hobby Lobby making a First Amendment case. Look, we have a First Amendment right, and we can't be compelled to violate our own conscience by the Obamacare. We want you to give us a waiver. The judge said no, and here's what he said. Hobby Lobby and Mardel are not religious organizations. Plaintiffs have not cited, and the court has not found any case concluding that secular for-profit corporations such as Hobby Lobby and Mardel have a constitutional right to the free exercise of religion. Now, and so the federal judge, he's an agent of the federal government. He's an agent of the central government, and he shuts this down. Said, no, you have to pay whether it violates your conscience or your religion or not. Now, two problems with this judge's ruling. Number one, he is assuming that the First Amendment only applies to religious organizations. That is not true. The rights that are enshrined for us in the Bill of Rights are individual rights. They are granted to us by our Creator. They are bestowed upon us from the hand of the Creator, and they are bestowed upon us as individuals. They are not group rights. They are not organizational rights. They are personal rights. And every person in the United States has these rights, whether they belong to a religious organization or not. Whether there's a religious organization involved is completely irrelevant. It's the judges make the same mistake with freedom of the press. They mistakenly believe that freedom of the press applies only to news organizations. They're the only ones that have freedom of the press, news organizations. That is an individual right. So the First Amendment right to freedom to publish, that belongs to bloggers and to tweeters as much as it belongs to the New York Times or NBC News. It's an individual right. It's not a corporate right. It's not a group right. So that's what this judge completely fails to understand. He thinks because this is an organization acting that somehow they have no First Amendment protections. But remember, Hobby Lobby consists of individuals. They have a CEO who is one guy. He's an individual. Forget his first name. His last name is Green. But Mr. Green is an individual. The people that run that company, the board, they're made up of individuals. They are acting collectively, but they are acting as individuals. Every single one of them has a constitutional right to the free exercise of religion. So that's the first place where this judge goes completely wrong, is the Constitution protects individual rights, not group rights. So you have an individual right. If you belong to a religious organization, then your religious organization has that right because you have the right, not the organization. The organization doesn't have the right. You have the right. And because you are a part of the organization, therefore, the organization has that right because every organization is made up of what? It's made up of individuals. So that's strike one for this judge. Now, the strike number two is, what does the First Amendment prohibit? It says Congress shall make no law prohibiting the free exercise of religion. I mean, that's as plain as it can be. Congress, which is the central government, the federal government, because remember the way our form of government was designed to operate, Congress makes the laws. The executive branch, that's the president and the executive branch, they enforce the law, they implement the law, and the judiciary applies the law when there's a dispute. So Congress makes the law, the executive branch enforces the law, and the judicial branch applies the law. But remember, the president can't do anything. He's not supposed to do anything except apply or enforce the laws that Congress has passed. And the Supreme Court, their job is to apply the Constitution and the laws that Congress passes. In other words, they got no power of action. They're not supposed to have any power of action until Congress actually passes a law. So notice then that the central government is prohibited by the First Amendment from interfering with the free exercise of religion. The president can't do it, and the judiciary can't do it. Congress can't do it. But no branch of the central government is allowed to interfere with the free exercise of religion. Congress is specifically prohibited from passing a law that prohibits the free exercise of religion. That's exactly what Obamacare does. It is a law passed by Congress that prohibits the free exercise of religion for people like the CEO of Hobby Lobby and for Christian organizations and Catholic hospitals and Catholic universities. So what this federal judge doesn't realize, when he issues a ruling that prohibits the free exercise of religion for Hobby Lobby, who is the one who is violating the Constitution? Who's the actor here who is violating the First Amendment of the Constitution? It would be this judge. Hobby Lobby's not violating it. This federal judge is violating it by saying that the central government has the right to prohibit the free exercise of religion when the Constitution that he's sworn to uphold says, no, you cannot do that thing at all. Anyway, 888-589-8840, number to call if you want to weigh in on some of what we've talked about here. Again, the main principle here is that the Constitution enshrines individual rights, not group rights, not collective rights, but individual rights. Now, here is President Obama at least paying lip service. This is clip 3. President Obama at least paying lip service to what we just talked about, the concept of the separation of powers. Would that he actually believed it and lived it. Let's listen.
I, as the President of the United States, make determinations that the military then carries out, not the other way around. As President and Commander-in-Chief, I have that responsibility because I'm accountable to the people. Now, on the other hand, as President, I cannot just impose my will on Congress, the Congress of the United States, even though sometimes I wish I could.
Well, if only he didn't do that. But the Heritage Foundation has said, look, he's done this at least 40 times. They have 40 specific instances where he has imposed his will on Congress or over Congress or in violation of Congress or ignoring what Congress has said and done. Now, speaking of the Constitution, let's drop down to clip 10, Rob, if we can. This is Nancy Pelosi, that noted constitutional expert. Listen to this. This is somebody that would be the Speaker of the House if the Democrats had won the House. This is someone who has has ultimate responsibility to understand and to follow the Constitution in all of her deliberations. Listen to this.
Unless there is an anti-government ideology on this part of the Republicans to undermine any of the goodwill that is there.
Two deals or one?
I'm sorry?
2 agreements, 2 bargains, or 1 bargain?
I'm sorry.
Fiscal cliff, debt ceiling. Are there 2 separate?
Oh, I see what you mean. I'm sorry. Well, I would hope not. I would hope that by now, well, I'm with the 11th Amendment, so is it the 11th Amendment that 14th is it? Whatever it is, I'm with the Constitution of the United States.
Whatever it is, I'm with the Constitution of the United States. Now, I frankly had no idea what she was talking about. And more to the point, Nancy Pelosi had no idea what she was talking about. Now, let's grab clip 13, Rob, and jump down a couple of clips. This is a pizza place owner talking about the impact of Obamacare. Speaking of an unconstitutional piece of legislation, the impact of Obamacare on his business. Let's listen.
So we have to manage down our staffing by 4 part-time or 2 full-time people over the 2013 year from the beginning to the end, or we qualify as big business and that minimum $40,000 tax and $2,000 per head. We can't afford that. It's just pizza. I was so ready for growth. We were going to add 100 jobs this year with the new pizza restaurants and even some grocery stores. And there's just no money for it. I cannot pay my staff and pay all these taxes. There's only so much blood you can get out of a turnip. Every restaurant that you eat at is impacted negatively by this law.
So there's a small business owner said, look, I was going to hire 100 people next year. Now I can't do it because of Obamacare, because of the regulations that are going to be imposed on me and my business. I cannot do it. Here's a hospital in Orlando Health. They're cutting up to 400 jobs starting immediately. Second paragraph in the Orlando Sentinel, the move is part of a broader effort to position the hospital system for the health care overhaul. So what's the Orlando Sentinel saying is hospital being forced to fire 400 people because of Obamacare. Hey, let's hear it for the little guy. Back in 2.